Gartland Law presents Taxes, the IRS, and You with your host, Bernie Gartland. Taxes, the IRS, and You is a different kind of show that'll help you solve your tax problems. As former Deputy Attorney General of the state of Delaware, and with over 25 years of experience as sole practitioner in both Delaware and California, the name Bernie Gartland has become synonymous with taxes. And now your host, Bernie Gartland.
Hey everybody, Bernie Gartland. Name of the program is Taxes, the IRS, and You, and we consider ourselves a different kind of show. Now, what do I mean a different kind of show? Originally, for the last 20 some odd years, we have been doing tax problem solving. You have a tax problem, you haven't paid your taxes, or and the IRS is coming after you, or you didn't file your tax returns, the IRS or state of California filed a tax return for you. Now they say you owe all this kind of money, and we solve your problems. There's several different steps that we take in consideration. We normally say there's a three-part problem-solving process for all your tax problems. In addition to that concept, we also, every Wednesday, in addition to that tax problem-solving concept, we present you additional information that's pertinent to you and your future, and how to get control back in your life and have that control give you a future. We bring in a tax expert for real estate, for trusts and estates and probate offshore, why you should not go offshore. An attorney from Phoenix. We bring on people such as a motivational speaker that'll tell you how to get over your fear of the Internal Revenue Service. We'll bring on people that tell you how to invest with your 401k into real estate. And we brought on Mike Wales from Paychecks to show you how you can set up your small businesses so you don't have a tax problem. And every now and then we get into something that's really, really heavy, really important, and most people do not understand what we're talking about. I know that sounds crazy. Why don't they know what we're talking about? You're going to understand at the close of today's seminar, workshop, program, whatever you want to call it, you're going to understand how heavy this is and the ramifications. And the subject matter is your IRA, that's your retirement program, is your IRA really an IRA? Now let me say that again, because that, I know you're all sitting there looking at the television going like, what does he mean is my IRA is an IRA? I know it is. I have an IRA with Merrill Lynch. I have it with Wells Fargo. I have an IRA with Charles Schwab. I have an IRA. And every year they tell me I have an IRA. Well, you may not have an IRA. And right now I'm going to introduce you to one of our regular panel members, David Wiesen, who's a tax attorney with Gartland Law. And David, welcome aboard.
Thanks for having me this morning.
You have an announcement from the Internal Revenue Service right there, don't you?
Yeah, let me
and it's a recent announcement. It's very important you guys and gals out there understand. This is a recent announcement. And Dave's going to read you in a little bit of pertinent part what it is.
That's right. And this is a recent announcement from the IRS in response to an announcement from the Department of Labor back in October of 2011. Okay, so let me start reading that. This announcement provides temporary relief, let me focus on that, temporary relief with respect to IRAs in circumstances in which the IRA owner or the individual have signed certain indemnification agreements or granting certain security interests in accounts that may have an effect on their IRAs.
All right, let's go through that again. This is an IRS announcement that's saying to the public, this announcement provides temporary relief with respect to IRAs in circumstances with the IRA's owners. That means you guys and gals out there, IRA owners, IRAs owners have signed certain indemnification contracts and agreements creating certain security interests in your account or and I will add something to this, and other assets. Okay, but there's more to it, isn't there, Dave?
Yeah, absolutely. Well, this announcement by the IRS is in response to what the Department of Labor has already said. They issued an advisory opinion also at the end of 2011 regarding circumstances under which an individual IRA owner in the agreement indemnifies the broker. I'm sorry, it's an agreement to indemnify the broker in order to cover indebtedness or arising from the individual's IRA with the broker, where it would be an impermissible extension of credit.
Okay. In layman's term, what it says is this. The Department of Labor has issued a statement that the IRS is responding to. The Department of Labor basically has said in their advisory opinion, and by the way, there was one on October the 20th of 2011, but the first advisory opinion came out in 09. And it's important that everybody understands that it came out in 09 first. And what it says is that the brokers' agreements, Charles Schwab, Merrill Lynch, possibly Fidelity, Wells Fargo, have in their agreements an indemnification clause that says if we have a shortfall, we can go after certain of your assets to take care of that shortfall. And you're sitting there saying, wait a minute, and you IRA owners, you better get hold of your applications, because if you look at there's any kind of a surety, indemnification, or guarantee in your application, the Department of Labor says that it's not a valid application.
Right, right. Yeah.
And it is saying that it's not a valid IRA. Is that correct?
It's not a valid IRA. And where you need to look is, when this actually occurs, is at the time that you sign your application for your IRA.
Right.
If you give a security interest to the broker,
right,
then it's what's called a prohibited transaction under 4975.
That's an Internal Revenue Code section 4975, okay.
And what it means is that your IRA never became an IRA.
Then what is it?
It's just a savings account.
It's a savings account, a cash account. And right now, the folks out there are going, wait a minute, this is all gobbledygook to me. As a matter of fact, I had the occasion about, a month ago to have a conversation with a multimillionaire who had major real estate investments, and some of them may be within his IRA. And he also was a financial planner. And I had this conversation. He asked me what I did for a living. I told him, and I told him about the what we call the blown up IRAs. Flat out would not believe what I was saying, and he kept saying to me, "Well, the IRS will never make a determination that the applications are void." And I said, "Yeah, that's correct. The IRS could never." He said would. I said could never make a statement saying the IRA application is void. And he looked at me and said, well, what do you mean by that? I said, because they don't have the authority. And he said, what do you mean? And I started thinking to myself, wait a minute, you're a financial planner, and you do not know the federal agency that has the ability to control what you do or don't do with an IRA? He didn't know. Folks, it's the Department of Labor. It's not the IRS. It's not Department of Treasury. It's not the SEC. It's the Department of Labor. 1978 Tax Reform Act under President Carter shifted all that responsibility to the Department of Labor. What David just read you was an announcement from the Internal Revenue Service that says, because of this announcement, because of this ruling, this advisory opinion, we are going to provide temporary relief. Now, the thing that we haven't pointed out is temporary relief for what?
Right, what are the ramifications?
What are the ramifications? Well, we're going to go into that. Wait a minute. Why is the IRS issuing a statement, we're giving you temporary relief of what? Well, we're going to go into that statement now. We're going to go to commercial break right now. And when we get back from our commercial break, David, you and I are going to go into more of the history of this and what is being done. And I also want to tell you guys and gals out there, do not panic, even though you're panicking at this point. Well, I think you're kind of confused and panicking at the same time. But we're going to outline all of this to you and tell you what's going on right now in Washington, D.C. that you can't get from Wall Street Journal or any news media. And so we'll be right back and we'll continue this conversation.
Visit us on the web at www.gartlandlaw.com.
Did you know that you can solve all your IRS problems with just 3 easy steps? Hi, I'm Bernie Gartland. We have helped thousands of people with our 3-part problem-solving process. We analyze your situation, whether big or small, break it down to 3 parts, apply our process to it. This proven process has worked for others and it will work for you. Let us help you put control back in your life and have that control give you a future with just 3 easy steps. No more sleepless nights. Oh, hi everybody, Bernie Garland, name of the program is Taxes, the IRS and You. We welcome you back. We're talking about whether your IRA is an IRA or not an IRA, and David Wiesen, who is our panel member, who is also a tax attorney with Gartland Law, has read to you in partial format the announcement from the Internal Revenue Service saying that they were going to give temporary relief, and we're going to talk to you about, well, wait a minute, if they don't give you temporary relief, what are they going to do? I'm going to get to that in a moment. You all should be saying to yourself, well, wait a minute, how does this affect me? I mean, you're saying that those applications that I had with Schwab, Merrill Lynch, and Wells Fargo, and a few other of the major brokers, that their application was defective, and the Department of Labor said that they are defective, blown up, and never became IRAs? That's true. On April the 4th, 2011, there was a class action suit that was filed against Charles Schwab. On June the 15th of 2011, think about this for a minute. When somebody files a class action suit, it takes what, 5, 10, 15, 20 years?
You expect a long time.
April the 4th, 2011, a class action suit was filed against Charles Schwab. On June the 15th of 2011, they entered into a settlement program. And as a matter of fact, I have my hands right here. It says, this is from Charles Schwab, frequently asked questions, and they put into a frequently asked questions email to all their IRA holders of why they entered into a settlement process, because their application was void by Department of Labor and by the Internal Revenue Code section
4975 and also 408. And if you want to look at that, it's available online at the Charles Schwab website.
There you go. So the people, see, here what the problem we had is that an associate and I, for the last 3 years, when we found out about this, have been trying to tell financial planners, CPAs, attorneys that do the planning for everybody, estate planning, and also IRA applications of what was going on. Nobody believed us. They booed us off the stage, called us charlatans or whatever, and I'm sitting there going, like this gentleman, this multimillionaire, he's sitting there saying, well, I don't believe it unless the IRS does it. Well, it's already been done. It was done right here, October 27, 2009, the first advisory opinion came out. I also want to show you, you guys and gals, something, is that I'm holding in my hands, it doesn't matter that you see it, you can always get it. It's the United States Bankruptcy Court for the Eastern District of Tennessee. And the question on this was, it was a Richard Starr, S-T-A-R, the bankruptcy judge, whether Merrill Lynch IRA is qualified under the applicable IRS code sections. And one of the pages, on page 13, it says, as incongruous as it appears, based on the language of the client relation agreement, that's the application.
The application.
Signed by the debtor, the mere opening of the Merrill Lynch IRA caused the debtor to participate in a prohibitive transaction under 4975. The mere opening caused the debtor to participate in a prohibited transaction. What it said, it had the language that the Department of Labor has already ruled is void, and this IRA never became an IRA. And Dave?
Yeah, what was the punchline on that?
The punchline on that was, in accordance with the above, the debtor is not entitled to an exemption of the $61,646 in his Merrill Lynch IRA. Order consistent with memorandum will be entered. And what was that order? The order was
turn over the money.
Turn the money over to the trustee.
It's going to be distributed.
So there's a court in Tennessee already. Oh, by the way,
before you move along, just so the people, if they want to look it up, the name of that case is N. Ray Daly, D-A-L-E-Y, and it can be found at 459 BR 270, and that's out of the bankruptcy court in the Eastern District of Tennessee in 2011.
Okay. And how else is this affected? Well, you say, well, wait a minute. You're saying that the Merrill Lynch, Charles Schwab, these are big firms, big broker firms, you know. They're not a little law firm out of Palm Desert, California. But we know this, and the media is not picking up on it, and the brokers are not picking up on it. But it is absolutely true at this point in time. And you're saying, well, wait a minute. There's an indemnification. So if we have a shortfall, they're going to go after other assets? Yeah, that's what it said. Well, that'll never happen. Well, United States Court in the Eastern District of New York, in a Kaminsky case, order granting motion for relief from automatic stay. Merrill Lynch interest in the IRA account, order the motion is granted. What Merrill Lynch did was they got a shortfall. They have this agreement that says they can go after other assets to indemnify, and they won their case in court. They won their case in court. So when people say, you know, well, wait a minute, you're making much ado about nothing. Well, guess what? It's happening. And by the way, the temporary relief that we're talking about is there's approximately $17.1 trillion in IRAs sitting out there.
How many millions of people have IRAs? Probably
how many millions of
70 or 80
people
million.
have IRAs? And what the IRS is saying is, this is kind of like, it's almost in code language, temporary relief. Temporary relief from what? If these IRAs never became IRAs, they're blown up.
Right. And blow up is defined in the Internal Revenue Code under 408 as they're fully distributed.
Fully distributed. And if they were fully distributed, let's say you had an IRA that was created in 1999.
Sure.
It was fully distributed in 1999, and the IRS can go after tax, penalties, and interest on all the IRA from 1990, from January the 1st of that year all the way through.
Sure. Well,
so we're sitting here and having $17 trillion that is ready to be taxed by the Internal Revenue Service, but they're saying we're going to give temporary relief if the Department of Labor issues a class exemption.
Mm-hmm.
As of right now, is there any class exemption from the DOL?
No, it's just temporary. As we're seeing in those cases that you're reading,
right,
that although maybe the Department of Labor and the IRS is not doing anything, we don't have protection from the U.S. the trustees in bankruptcy cases, and we don't have protection from judgment creditors. If you have a judgment against somebody who has an IRA that's blown up, that IRA is not safe today.
And the perfect example that I gave is that you got a general contractor hires a subcontractor. Subcontractor messes up. General contractor sues the subcontractor. Subcontractor gets a judgment, and subcontractor at the debtor's examination says, "Hey, I have a house, but the homestead statute protects my house. And oh, by the way, I got $250,000 in my IRA, and IRA is exempt from collections." And the contractor's attorney says, "Can we see the application?" And it's a Merrill Lynch application, a Charles Schwab application. It's void, and that now is available. Okay, so I always use when I talk about this, I always use a Perryism. You know, when the other attorney on the other side goes, "Whoops." Okay, so it is not just the IRS going after taxing and by the way, what a catastrophic event if the IRS decides to tax $17.1 trillion. If you think Wall Street, the occupation at Wall Street is going to cause chaos in this country, wait till you see every IRA holder who's now saying, my IRA's been there since 1995, and you're telling me I owe tax, penalties, interest since 1995, and the IRS can come in and take everything I owe?
Right, and in your agreement, you've agreed to indemnify the broker.
To indemnify the broker, you know. So anyway, there's more to this story. There's more to the story. So when we come back from our last commercial, and by the way, we don't have time to go all the ramifications. There's so much more to this, but this is so important. Is your IRA an IRA? You better, ladies and gentlemen, you better go down to your broker and get the application. And if they have any of the wording that the Department of Labor has already identified as prohibited transaction on special codes, then your IRA is not an IRA, and you better start talking to your broker to get to the Department of Labor. So, Dave, we'll talk about this when we come back from our commercial.
Stay tuned. Bernie will be right back with more tax solutions.
If these four areas are controlling your life, let me show you how through either a Chapter 7 bankruptcy or a Chapter 13 bankruptcy, we can put control back in your life and have that control give you a future. Call me today for a free consultation. Facing bankruptcy have led many people to believe it was the end of the line, when in fact it was their doorway to a new beginning. Hi, I'm Bernie Gartland. For a full explanation of what a Chapter 7 or a Chapter 13 bankruptcy is, call me today for a free consultation. Hi, everybody. Bernie Gartland. The name of the program is Taxes, the IRS, and You. We are exploring an incredibly important concept that is reality that Associate and I have been going on the lecture tour for the last 3 years trying to get certified financial planners, brokers, etc., with knowledgeable in their field to understand that they're putting people in IRAs that are not IRAs because of the application is void as determined by the Department of Labor. By the way, I understand that the major brokers across the United States have recognized all this and have now, as of like maybe January the 1st of 2010 or 2011, have started changing their application. So the proof is in the pudding that they're aware of it and they've changed it. But I also want to read to you another paragraph that's very disturbing in the announcement for the Internal Revenue Service. What the Internal Revenue Service said is that pending the Department of Labor issuing a class exemption, they are not going to go after the taxing of the IRAs, but they're waiting for DOL, Department of Labor, to issue the class exemption, and they haven't done it yet. But they also added something, and I'm going to read it to you. Provided there has been no execution or other enforcement pursuant to the agreement against the assets of the IRA account of the individual granting the security interest or entering into the cross-collateralization agreement. What that means is, when Merrill Lynch went after the assets of that other person, the IRS is saying that we're not going to give relief. That was a transaction that is now taxable. And we're sitting there going, wait a minute. The broker just took my assets pursuant to an invalid agreement, and yet I'm being taxed. Stay tuned for future. This is incredible. Think about this for a minute. Okay, now, let's go one step further. And then Dave's going to give you some remedies, by the way, because all is not lost. But I want you all to be aware of what's going on, because if you go to your broker right now and you tell them what we said here today, they're going to say that can't be true. Well, go to the different websites, the Department of Labor and everything. Also, go to a company called SIFMA. Now, what is SIFMA? Remember what we said is that the Internal Revenue Service said they're going to give temporary relief pending an application to give a class exemption. I have that request right here in my hands, dated December 12, 2011. It's sent to the Assistant Secretary of Labor, and the first sentence, Dear Madam Secretary, on behalf of the Securities Industry and Future Markets Association, SIFMA, we respectfully request that the Department provide temporary and permanent prohibitive transaction relief as a result of the Department recent advisory opinion. What does this say? Dave, what are they asking?
They want to save these IRAs if they can.
They want to save the IRAs, and they're saying this is a company representing the brokers that are saying to the DOL, please issue the class exemption. And then what I find this wording is very interesting, Dave. Absent relief, okay, absent the class exemption, okay, in order to avoid tax penalties on IRA owners and tax reporting penalties on financial institutions. Oh, who's being protected there? Trustees and non-bank custodians of IRAs may feel compelled to issue Forms 1099-R for all affected IRAs by the end of January. Moreover, these institutions may also feel compelled to communicate to all impacted IRA owners prior to that date in order to outline the issue and potential tax consequence. What that is saying is that, hey, if you don't give this a class exemption, we are issuing a 1099-R. And what is a 1099-R? It's a distribution.
Distribution, yeah.
And it goes back to the date that they started the IRA. If there's no class exemption, it goes back to 95, 99, 2005. And they're going to report it all and protect themselves by letting the clients know. So now, Dave, if somebody has a blown up IRA right now, $200,000 IRA, $50,000 IRA, and the Department of Labor does not give a class exemption, you came up with a great idea. What is that idea?
Well, my idea is that right now you're getting temporary relief from the Department of Labor and you're getting temporary relief from the IRS.
Right.
So why now? And we also know that bankruptcy trustees and creditors are starting to get keen to this and are starting to go after these IRAs. So why not now, while you're getting temporary relief, go ahead and move your money into an IRA that's good, that has the good language.
It's a good language.
And even though that's a what's it called? It's an excess distribution, right, or an excess funding contribution. And even though there's all sorts of problems from the IRS and the Department of Labor standpoint, right now they're giving temporary relief. So why not put it somewhere safe so at least the trustees in bankruptcy and creditors can't go after it.
And let me go over that again. If you have an IRA, check it. And if you're pre-2010 with Merrill Lynch or Wells Fargo or Schwab, you have a blown-up defective IRA application. It is not an IRA. What they're asking for, what SIMFA is asking for, is to get a class exemption. But there's no class exemption issued now. And you know, the wheels of justice churn very slowly. So you better get it put into a IRA that has the appropriate language to protect that under your IRA exemption now before the creditors get hold of it. If they issue a class exemption, you're home free. If they don't, the only downside is that you're going to get a 6% per year excess contribution, but at least it's protected. So what happens, folks, get hold of your broker, get your application. You can always email me at bernie@gartlandlaw.com and ask me questions about this. We've been delighted to talk to you about it. This subject is huge, and the word is not getting out, and that is why we are letting you know. See you next week. Good night, Dave.
Thanks for having me. Safe.